Thank you all so much for coming to this, which is our first official event of the Blockchain Law for Social Good Center since our move to USF Law on January 1st. So we welcome everyone. We're so grateful to have you here. If you're in the in-person audience, there are still lunches, and we will not be offended if you run out and grab a lunch and come right back. And I'm so delighted to introduce our panel today on DAO liability and regulation. And what I have learned over the years is that it's much more interesting to have folks introduce themselves than to have me read their bios off a piece of paper. And so what I'm going to do first, and actually my panelists don't even know I'm going to do this, I'm going to ask you to tell us about who you are and where you work, but also what drew you into blockchain, because I think that's always an interesting story to hear from folks as to how they broke into this space. And so we will start with Min.
Oh, I'm first.
You can be first.
Hi, everyone. I'm Min. I currently work at the Algorand Foundation, and I focus on ecosystem growth. So it's really looking at like how do we grow developers, how do we grow users, how do we grow projects, and also geographically, where do we focus our efforts on as well. I came to, well, I guess my first touch point with crypto, if you will. I was playing ping pong with some coworkers at this time. It was like 2014, maybe 2015, and Dogecoin had just launched, and we were playing ping pong for Doge. And I won some games and have a bunch of Doge on a computer that I then gave back. So I don't really know. But anyway, that was my first foray into crypto.
Hello, I'm Lisa Rubin. I'm a blockchain attorney. So I pretty much help companies that are in the blockchain space come up with creative legal solutions, since this is a very new field and the courts and the laws are just catching up. How I got into the space is I originally started my legal career as a litigator, so the type of attorney that goes to court. And I loved working on tech matters, and I started working more and more on crypto and blockchain. And I loved it so much, I've now switched over to do that full time. And so now I'm on the other side, and I advise companies on the laws to hopefully keep them out of the courtroom.
Hey y'all, my name is Nick. I'm a reporter and editor with CoinDesk. So I cover policy and regulation in crypto. Our team is basically based around the world. So anything going on in the European Union, the US, Italy, India, Hong Kong, we're trying to cover. It's naturally not very busy at all, especially now. I got into crypto. I was looking for a job, looking for an internship while still a student. And CoinDesk was the first place to hire me. So I figured, okay, sure. I'm sure Bitcoin can't be that weird. And turns out it was much weirder than that. And I kind of stuck with it. So here I am, more than 5 years later.
So as you can see, we have a really diverse panel of technical expertise, legal expertise, and policy expertise, which is great. So the first question I want to ask our audience in the room, how many of you know what a DAO is? Okay, vast majority. All right. For those for whom this might be your first introduction to DAOs, we thought we'd kick it off by asking Min to just tell us, what is a DAO?
What is
In
a DAO?
3 minutes or less. Yeah.
Well, so I'll take a stab, and it sounds like many of you already are familiar with it. So that's actually a really good place to start. So, DAO stands for decentralized autonomous organizations. And really, I think it's more of a concept, right? That it's governed not by a single entity or a person or a group of people, but actually is governed by the owners of the DAO, of this organization. Every single member of the organization basically has a say in the future governance of this organization. Some good examples of DAOs, I would say, are, back in 2020 during the DeFi spring, right? Like Uniswap, for example, is a DAO. It's probably one of the biggest. We have like over 2.7 billion in treasury, so that's huge. And then there are other, maybe a relevant example of a DAO for this group is the Constitution DAO, right? Where a bunch of people over the course of a week raised, I think, 40 million to try to buy the copies of the Constitution. And then, there are other DAOs, for example, like Flamingo DAO, which is all about, NFTs and taking ownership. Taking a part owner in an NFT and being able to, participate in how to kind of govern investments in NFTs and, all these different various decisions that you would want to do. So basically DAOs run the gamut. And I'd say that I think they're about, just to give everybody a sense of how big are DAOs. I think they're about like 5,000 DAOs, about 1,000 of these are active DAOs. Last I checked, I think there might have been a CoinDesk data point. It was like $10 billion worth of assets that are locked in using DAO governance tokens. So it's about 10 billion. And it's about like a couple million wallets. So that just kind of gives you a sense for how big are these DAOs.
Great, thanks. So it's a new entity, right, which presents lots of legal and regulatory and policy challenges. So our next question goes to Nick to ask, what are some of these challenges? What are you seeing?
So I guess in the US, probably the biggest one is, as Min said, it's almost more of a concept. So a lot of places, you don't really have anything that accounts for the existence of a DAO. So, if you're trying to set up a DAO to do something, chances are there's no real applicable state or federal regulation unless you're in Wyoming, which I think is the only state at this point that has any kind of explicit rule around DAOs. So, there are a lot of questions around, who are your company officers, which you don't have in a DAO. So when you're trying to set up one of these companies or one of these DAOs as a company, incorporate it, those are just some of the kind of basic issues you come across. And then the other side of being in the litigation side, regulatory agencies like the CFTC might still want to say, okay, well, you created this DAO to try and do this conduct, but that's still illegal. And so we're going to sue you. And the CFTC's issues have been trying to identify and locate members of DAOs and properly serve them. What's happened is so far they've just sued the entire DAO, being the one example, rather than try and identify any actual individuals or parties that might be responsible for whatever illicit conduct. And that's raised its own red flags among the industry because if you just participated in a DAO once and you don't really know what they're doing now, you might still get become part of that lawsuit because you participated in it at one point and then they got sued. So it's weird gray area for a lot of things that DAOs might try to do.
We're going to talk about UkiDAO, but can I just ask you a follow-up? So because we're all, we have a lot of law students in the room, can you talk about the service process and how the CFTC tries to serve UkiDAO members?
Yeah, so first the CFTC posted on a forum that UkiDAO had on his website, and then they posted in a help chatbot and argued in court that these two posts were sufficient to act as service. There were, I don't even know how many, there were like 4 or 5 different efforts at amicus briefs to argue that that's not how it should be done, that the CFTC should be required to, at least try and identify some people who are part of the DAO and serve them directly. The other argument was that, you don't know that just because you posted it on a website that, the DAO is aware of it. So those arguments didn't really get too far. The judge in the UkiDAO case ruled that 2 individuals who had previously settled with the CFTC because they founded the company that came before the DAO counted as service. And yeah, so basically what we're at right now is, you can post on a forum webpage and that might be enough.
Not what we learn in Civ Pro, is that right? And yet somehow I counted. Okay, so Lisa, you're on the ground as a lawyer in this space. And given that it's a little scary to think you might have purchased a token or somehow joined a DAO and then they post something and all of a sudden you're legally served, what are your clients asking you about?
So I would say we represent a few DAOs and CDAOs in and out all the time. I would say 2 main questions that we get from people in DAOs that have some questions are, 1, do they need a legal entity? And two, if they do need a legal entity, what type do they need? So as to the first question, generally, as stated in the UkiDAO case, a bunch of people come together for a common purpose, and especially if it's for-profit purpose, and they don't do the additional step of filing paperwork with the state Secretary of State that they want to do business in, they may not have a legal protection and would be known as an unincorporated association. With that, it's a fancy name for meaning that you are not protected. So if you sign a contract on behalf of the DAO and you think that you're signing it on behalf of the DAO, like $1 million contract, you're actually, excuse me, you could just be actually signing it on behalf of yourself. So if you sign that contract, you're saying you're on behalf of the DAO, and then someone tries to sue for that $1 million, they could just come after you personally and potentially take your house. So those are the risks of not having a legal entity around a DAO when you're trying to do business or enter into contracts. So yes, generally a DAO should have some kind of legal wrapper. Now, the second question of which entity should you use is a lot more complicated, and there is no right answer for everyone. There really is no perfect answer in general. It's really dependent on like a fact specific analysis. And I know that's a lawyer answer, but you have to look at each individual DAO and what is the most important thing that they're trying to protect. If they're trying to protect like liability of the people, that's one consideration. If they want to be based offshore, onshore, for profit, not for profit. So there's a bunch of different ways to structure it. I think that one common misconception that we see a lot is a DAO says that they want to be based offshore and they think they're not going to be subject to US law and regulation, but it's a lot more complicated. So even if someone is based offshore in a different country, but then they start doing business with US customers or business like transactions in the US, they'll probably still be subject to US law. So it actually would not really benefit them to be offshore, and it'll be a lot more complicated and expensive when maybe for that DAO it would be better to actually just be based in the US and a lot cheaper and simpler. So just a lot of considerations that go into it. It's a pretty complicated subject.
Question already. Yes, go for
Yeah,
it.
quick question. So when it comes to like the DAO having a legal entity, does the legal entity own the DAO, or does the DAO own the legal entity?
So there's ways to structure it. For example, you can have like if the DAO is for profit and they want to be able to, if they have profit, they want to distribute it to their individual members. Let's say they have a Delaware C Corp, which is traditional. So it's kind of strange because the law doesn't recognize the DAO. They'll only recognize a legal structure. So you may recognize yourself as a DAO, but the law is not going to recognize it. So you kind of become whatever you choose, an LLC corporation. So it's not, so I guess you could say in a way the DAO owns it or controls it, but it's really dependent on which structure, but the law will not recognize the DAO. The only kind of exception is, as they both mentioned, in certain states like Wyoming and stuff, they're trying to develop laws to make it easier. So you're just a DAO and you could be like a DAO LLC. But those are kind of still being tested. So it's not really certain how strong or if those are even the perfect fit. And some argue that the LLCs in those states are actually stricter than normal LLC laws because they require the smart contracts to be amendable. So you have to be able, they can't be like stuck in a certain code. You have to be able to change it. And like normal LLC laws don't require that. So it's not a perfect fit. Did I answer your question?
Yeah, so it's like, if you do it that way, and you have new members coming onto the DAO every day and like ownership is changing, I wonder how that changes in like the actual business.
I mean, that is really interesting if you're like asking who's going to be considered in control. I think that's something the law is not really sure on. So like in the UkiDAO case, they went after the two people that they thought were they believed to be the founders of the whole protocol, responsible for this like trading system, which they found to be illegal, but then they couldn't find the rest of the people. And even if they did, who do they need to serve? Because there's like too many people, they don't know who they are. So I don't think there is an actual legal answer to your question.
So this is what I say in blockchain law class all the time. There is no actual answer. What's the federal cohesive framework for regulation in the US? There isn't one, right? So let's try to write it ourselves, shall we? I mean, we might as well. So the next question that we're gonna talk about the UkiDAO case, but I thought we might just pause for a moment and think about the social good aspects of DAOs, right? So the title of this panel is, can you be accidentally liable? We've now learned the answer is yes, right? And so a lot of folks are interested in coming together as a DAO in order to build community, right? The DAOs are a really cool way that you can join with other like-minded people and build community. It's also the very essence of democracy, right? To have an organization that doesn't have the hierarchical structure of a corporation, but actually gives everyone a voice potentially in what they're doing. So it's kind of interesting that something that would attract people who are not interested in traditional structures has no law yet that applies to it, right? And the Uki DAO case is a great example. So yes, there's Constitution DAO, there's Charity DAO, there's folks coming together to support. I know there's a DAO to support women-owned startups, right? People who want to invest in women-owned startups. But there are these pitfalls that folks need to be aware of as you're heading into, if you're interested in heading into a DAO, which takes us to Uki DAO and the folks who are living those pitfalls every day right now. So Nick, as our journalist on the panel, could you give us an update on what happened? We talked about service and then what happened with Uki DAO.
Well, the DAO itself never responded to the claim. The DAO was aware because shortly after the lawsuit was filed, they firewalled the entire US. If you're in the US and you're trying to access the website or their trading platform, you couldn't. So clearly, enough people who are part of the DAO were aware. But what ended up happening was the judge just ruled, okay, well, the DAO has not responded, therefore I'm going to find in favor of the CFTC. And I think now they're trying to figure out, I think the CFTC is trying to figure out next steps. But at the end of the day, if you've ever used Uki DAO or you voted as part of the DAO, then there's a good chance that that means the CFTC somewhere is thinking, okay, well, you may have violated, commodities law, and we want to fine you. Beyond that, I think we're just trying to wait and see if the CFTC has any kind of follow-up on what they plan to do now that the suit has been sort of decided. Doesn't look like there's going to be an appeal, and the amicus arguments are really not going to go much further at this point.
So does that mean that folks who may have participated in Uki are just sitting waiting to see if they get discovered?
Seems like it.
Yeah. And the court did say something like, we welcome anybody or we invite people to come forward to represent Uki DAO in court, knowing that all of your personal assets may be at risk if you were to identify yourself in court, right? So it's not surprising that folks didn't show up. If I was their lawyer, that would be the exact advice that I would follow, right? Okay, it looks like we have another question.
Is there any information on what they plan on doing with the international participants of the DAO?
I don't think the CFTC has commented on that part. I'm not a lawyer, so I'm actually not even sure what the CFTC could do about the international participants. But, like I said, the DAO did firewall, or like the platform firewall of the US. If you're using a US IP address to access it, you can't anymore. So, just looking at other cases, my guess is the CFTC is going to say, okay, well, we can't really do much about the international participants, so we're not going to worry too much about that. Focus on anyone we can find in the US. But that's pure speculation, just based on some other cases that happened, more recently with the SEC and other entities. So that's just the best guess, unfortunately.
Yeah.
We know how many participants there were in,
We do not. We know that based on I forget what it was. I think based on token addresses, CoinDesk had an initial analysis that showed that weren't online. It was not a very active DAO. It was not a particularly heavily voted on one. They did have an active Telegram channel, and they had a sort of active Discord channel. So people were at least aware of the DAO and aware of what it provided. But, and this is, I think, another part where things get a little also weirder. The amount of activity, the volume of activity in the Telegram and Discord channels far outweighed the amount of activity on the actual addresses. So if you're a token voter, or token holder and voter, then I assume that means you're part of, you might be liable. But if you just chat in the Telegram group, I assume you're not. And there was a pretty stark disconnect between those two types of activity.
Were decisions being made in the Telegram chat?
Not really.
Not really?
You could be a token holder and not vote as well.
Right.
And then the question is, yeah, I mean, I think actually to Lisa's point, the international question is a good one, right? Like, it doesn't matter where the actual entity is based. If you're in the US and you are a member of this DAO by this token, if you voted, that's a pretty big signal. And then even if you didn't vote, like holding that token, it's actually some legal consequences as well, so.
What if I voted no? I don't think this is legal and I don't want to do it. Does that open me up then?
Is that on
to-
chain voting? Is it captured on the blockchain?
Do we know the answer? Actually, what if I voted no?
I mean, I don't think that theory has been tested on courts, was probably just speculation, but I think that would be a good argument that you were not one of the leaders trying to do something illegal, so you shouldn't be held enforceable for the whole DAO end up doing something illegal. So I think there would be a pretty good argument there.
As long as it was on chain.
You wanna get the
record.
Yeah, you need to
Yeah.
kind of prove, like showing voted against it or something.
This question did come up during the Oogie DAO, like the conversation around the Oogie DAO case. I don't think it was resolved, but that was a huge point of discussion when that case was ongoing, right after the CFTC filed.
It seems like in corporate law, if you're on record of voting against a decision that ends up in the breach of fiduciary duty, you have a good argument to try to escape liability by saying, I knew this was illegal. Look, here's a record that I voted against it. I was not acting in breach of my fiduciary duty. I was acting in alignment with it. But if they hold that a DAO voter, even somebody who votes against a decision is liable, then that's a really stark separation from what we would traditionally do in corporate law. So that's very interesting. Okay, so our next question is around what does it all mean for folks who are trying to develop DAOs and for law students and lawyers who are trying to, might be considering joining a DAO or advising people around DAOs. And so I think we might just go down the line and ask from your perspectives, how has the Oogie DAO case changed things? What are you seeing with developers and clients?
Yeah, I mean, for us, looking at the Algorand ecosystem, just DAOs more broadly, not even necessarily, the impact of the Oogie DAO, but it's really tricky. It's really tricky and it takes a really long time to set up a DAO correctly. So, I know projects that are been around and they want to be a DAO, they want to do it right, and they took 6 months to figure out what the entities are. They're going to have so one of the projects on Algorand called Algorand, they're going to now, after 6 months of talking to their legal team, they have now settled on a Panama-based foundation plus a Panama-based international business group to run this entity. And they haven't even gotten to what the operating principles are of the DAO yet. They're still figuring out the voting mechanism. So just setting up that kind of initial structure takes a long time to get right and it's expensive. So that's just from a developer's point of view. And then the second piece is also a really important one, which is executing all of the rules that you're setting up for this DAO by this smart contract. And if you want to do everything on chain and you want to be as decentralized as possible, just having the right tools around that. And then I think then it goes into some of the, how do you prevent and how do you make it as transparent as possible such that when these votes happen, you capture it on chain and you can then use it as, as an argument or as a defense against any legal question. So I think just, it's even earlier than maybe some of the conversations here that I'm seeing, which is for projects, it's really about like, what's the right way for me to set up this DAO? What are the right tools that I need to be successful as a DAO? And then it's making sure that we're, structuring sort of all the participation. I mean, participation is really important too, right? Like you were saying, how Oogie DAO didn't have that many people participating. I think that's actually a challenge more broadly for a DAO, just having that same thing in real life, okay? Like people vote when you make it easy to vote and you don't vote when it's hard. And so I think DAOs face very similar challenges there too. So yeah.
Can you speak more to just the, I guess, legal incentive as well, as far as Panama specifically, incorporating or non-incorporating, just those early decisions that those?
Well, so I would just say generally, when you're choosing a location like Panama or Cayman Islands or BVI or some of the more popular ones, it's important to look at certain things as how flexible, like for example, in Switzerland, I've heard that like when you use a Switzerland entity, it's kind of hard, like once you have your board members or certain bylaws set up, it's like really hard to change it. Whereas if you're based in Delaware, it's like a lot more flexible, you can change things pretty easily, you can move people around. In certain countries, you have to be aware of like what are the reputational considerations, like are investors going to trust a entity based out of a certain country rather than another. Those are certain
Like
considerations. Tax considerations, yeah.
Yeah, I mean, there's just so many.
There's so
different
many.
With, I know, it's so hard. Yeah, it's just really. It's
You were gonna start one of.
I mean, so I would say most of the time, the actual, we see a lot that works for a lot. Like I said, there's no one size fits all, but usually Delaware corporation stock or non-stock is generally a lot of the times works best for a lot of the ones we see. Like I said, not one size fits all, but many times it ends up the simplest option works for a lot of them.
I actually think, by the way, if you're interested in like Flamingo DAO has a really nice, they lay out their structure really nicely. If you're ever curious, just to see how that they're an LLC, they have an operating agreement, and then they only accept accredited investors up to 100. Like they indicate very clearly that they don't consider themselves a security, but that they don't know, right? And so then they're setting them. So anyway, that's if you're ever
I've
curious.
seen them,
Yeah,
it's really,
well done.
really nice that they like put it up for everyone
Yeah.
to see, and they have like all the corporate structures and
Yeah.
paperwork,
Yeah,
so it's nice that they did that.
yeah, exactly. So, just to check it out, that's curious.
Good lawyering right there, right? Also LexDAO is one that a lot of law students are involved in. And if you look at LexDAO, at the very bottom, they have the whole, we are not a loose affiliation or an unincorporated association of people, like everything that you might think, right? Disclaimer. Law students, like the disclaimers on LexDAO's front page are pretty good for that exactly. Okay, great. Lisa, what are you seeing?
Yeah, so I guess back to the OkiDAO and the service issue, which is a really interesting legal issue. So just to put my litigation hat back on, I'm sure most of you already know this, but so like you start a litigation with a complaint. So it's the document that says who you're suing and why you're suing. That's like the very first step. And in order for the case to proceed, you have to make sure that the person you're suing gets this complaint, so that they know they're being sued, they know when they're supposed to respond and why they're being sued. And so in the CFTC case, CFTC had the complaint and had their allegations, but they had trouble letting the DAO know. And so there's all these rules, federal and state, of how, like, what's the right way to give proper service of this complaint so that they know that they are being sued and can like have a fair chance to respond. And so it was interesting because in all the court documents filed, the CFTC argued that they really tried to find all the people. Like, I mean, I don't really know, I wasn't there, but the argument is that they did try to find the people. There was on the website, there was no person, address, email, physical address, anything to actually reach a person other than the two founders they had already charged. And so it was just interesting because their argument was the DAO wanted to be reached by the public through their chat forum. That's how they communicate. There's activity in there. And so they posted the complaint and then asked the judge, they filed a motion. Motion is just asking the court for something. So they filed this motion, said like, we did the best we can. We wanted to post it on their chat. Is this sufficient? And then after they posted the complaint, there's all this activity in the chat. The DAO members are actually talking to each other. Hey guys, we got served. Look at this. How are we going to respond? And so that I think was what really did them in, because then the CFTC filed another like follow-up motion, be like, hey, look, and they attached it as an attachment. Like, look, they have this whole chat forum. They like screenshotted people chatting about it on Twitter in the forum. Like, how do we respond to this? Back and forth. It was actually like very fascinating. But I think that's maybe what pushed the judge over the edge. And I think something that was really interesting is in the order, it said like, I'm ruling this way that the chat room was okay to post it because it showed that at the end of the day, whether or not the rules were followed, that DAO clearly knows that they're being sued because they were talking about it and that this was a ruling for this specific case. So hopefully like it's not used in the future as like, oh, look, here's an example where you can just post on a fat form and it's fine for everyone, because that would be really not a great thing. So that's why it's important, or like that, it's kind of dangerous, because it could potentially, you don't know how it's gonna be used in the future to set precedent. But particularly in this case, was it the right decision? I'm not sure, but I'm more like, instead of trying to think of whether it was right or not, like, I know courts are just trying to deal with this for the first time. So I'm more focused on like, why did the court rule that way, so that we can advise our clients of like what may happen to them in a similar situation.
It's pretty scary to have to advise, you might get served through a checkbox, right?
Yeah.
Okay, Nick, we'll go to you, but.
Yeah, it seems like it's pretty high bar for the government to pass here. And so in addition to some of these service of process issues, I imagine they also encounter the challenge of trying to meet these heightened pleading standards. And so when they don't have enough information to plead with sufficient facts or meet that high burden, what does the government do? How do they sort of respond to that type of environment where not only is it challenging on service, but then they have a high pleading standard they have to meet?
And that's a really good point. And for those of you who don't know, like when you have a complaint where you're saying, I'm suing this person for these reasons, it has to meet a certain standard. It has to be good enough, or else the other side can get it kicked out of court, and it's not a good enough reason. So there is some standard that you have to reach. And if you're alleging something like fraud, it's even, you have to have really, really specific facts. They did this on this date, and this is why it was illegal. It's actually very difficult to meet for certain causes of action. So to your point, I think that it will be interesting. I guess it didn't really happen in this case, it's more speculation, but if someone didn't have enough facts to allege that someone actually did something illegal, and maybe who those people are or how the protocol worked or why it was illegal, it's very possible that the regulators would maybe get that complaint kicked out and wouldn't be able to move forward because they just don't have enough detail on how it happened. And I think, yeah, really quick, interestingly, like if they do, so what ended up happening, they filed the CFTC filed an entry of default, my litigation hat back on. It just means that we should win this whole case because the other side didn't respond, and you can actually win a case that way. And so that's pending, and now they're gonna have to file a follow-up motion proving like why they should win. But I think even if they do win, it will be hard if they can't find anyone to get them to actually pay. So we will see what happens.
Okay, Nick, how are you seeing this shape the landscape?
It's kind of one of two different actions I've seen, some DAOs try to go for. One is kind of the full speed ahead, whatever, courts are courts, we're, regulatory proof. So you have some DAOs that are spinning up that are just trying to, it's unclear if they've, spoken to lawyers, or have, counsel. They're just doing whatever. And I guess, and again, I'm not a lawyer, so this is speculation, but if they're not doing things like trading, crypto futures products, they're probably not going to be in too much danger from the CFTC. The other side is, as Min said, there are some DAOs or some groups that are trying to create DAOs that are now being a lot more cautious about it, trying to figure out, okay, well, if we do this, are we going to get sued? And, especially over the last couple of weeks, there's been a lot more, uncertainty is not the right word. There's a lot more concern that regulators are taking a much more stringent approach towards all things crypto, especially in the US. So some of the pitches that I've been getting, some of the emails I've been getting are a lot more cautious, a lot more kind of, here's the kind of thing we're trying to do, and we're raising money to do it, but we're not announcing that we're forming a DAO or anything. We're just in the early stages of exploring a DAO. And they're being a lot more cautious. But yeah, then again, on the other hand, you have the, people who are like, oh, we're creating a Valentine's Day DAO to do whatever. And they're launching, they're live, they're just hoping for a good time.
We have some questions, so go ahead.
Just going off your point there, I was wondering if you have a sense of whether regulators are maybe more dovish when it comes to DAO versus other blockchain-based activities, or like the Tornado Cash, how OFAC and CFTC went after them. Whether you see any parallels there, if there is some softening or.
I don't know if softening is the right word. I think what it is right now a lot of the regulators, the SEC, the CFTC, they're looking for the, the conduct and the types of entities that they can go after where they have confidence in what they're doing. So, for example, we saw the CFTC sue Gemini. We saw the SEC last week settle with Kraken. They're looking for, I don't want to say easy wins, but they're looking for cases that they can confidently say, okay, well, we have this defendant and they have done, this conduct, and we think that we're going to win. So we're either going to settle or we're going to sue. And a lot of DAOs right now, Tornado Cash is a good example of one where a lot of the members involved in that are not based in the US. We know who they are, but they're, based in Amsterdam or Russia or, wherever. And so they might get sued, but I think regulators are going to go after DAOs if they choose to, but they're going to wait until they're confident in, that they're not going to come up with the same issues that the CFTC had in HookyDAO, where you have, 5 different amicus, or amicus, I don't know, but 5 different groups trying to say, okay, well, the CFTC is wrong here. They're not going to defend themselves against, all these, court fights about, how they're serving the defendant, how they're processing all that. So I think it's going to be just a matter of time before we start seeing more cases against DAOs. And in the meantime, we're going to see just kind of more decentralized entities. This could also, like a lot of these centralized entities are older, more established. Their conduct, they have a longer history. It might be easier to find whatever evidence you need to find.
So this goes to something that crypto lawyers have been talking about a long time, and blockchain lawyers, which is this regulation by enforcement idea, right? The idea that instead of coming out and saying, okay, we have this brand new entity, we need to come up with some sort of structure that folks can follow so that they have a clear roadmap. Want to start a DAO, here's what you should do. But instead, we're seeing regulators say, well, this, as you just said, maybe not easy win, maybe we shouldn't say it, but you're exactly right. That's what they're going for, right? The easy win. They're like, this is clearly illegal. Let's go after this group and we know that we'll win. But that leaves those who are trying to figure out what the right path forward would be really out of luck. And in fact, at our conference last October, there were some in-house folks saying that they're advising their companies to go offshore because it's just too hard to figure out in the US what's going on. And HookyDAO is a great example, right? Like who saw that coming, right? That would be the case. So we are at about our almost 45-minute point. So I'm happy. There's so much else we could talk about. We have 2 huge things that just went down in the last week that we could talk about, which we're happy to do. Or we'll take questions from the audience if we want to keep it limited just to DAOs, kind of wherever the room wants to go. Really. Are there any other questions around DAOs and regulation and the way that you could be accidentally liable? And actually, good point. Let me take some from, do we have any?
Yeah, we have one from Zoom here.
Okay.
So this goes back to structure. And so the question is, if the voting power in the DAO is prorated to investments, wouldn't the person holding the majority be responsible instead of a small token holder?
I think that would be a good argument, but since it's not tested in court, all the laws are either like, Congress either creates the laws and you follow them, or it's created by someone sues each other in court, and then that becomes like judicial law. So until there's really like a court action, a Congress action, it's kind of all speculation. But I do think that would be a good argument that if someone is not even really participating, maybe they shouldn't be as liable as someone who has a ton of tokens and is voting on everything. But it's to be determined.
And do you think that it also matters whether there are other decisions that these token holders get to make as well, right? Like, it's not just, in some cases, it's not just about investment, it's also, more operational decisions. I mean, I guess it depends on the DAO.
Yeah, I think that would be a good argument too, if someone is just voting on like certain, like operational things and other people are voting on things that they end up getting charged for in a litigation. I think that's a pretty complicated area, but I think that there should be a good argument of that there should be a line to be drawn that not every single person needs to be equally liable for something.
Which raises another question, which would go to Nick, which is, do you think some people like this idea that I can push it a little bit, see where it goes, and then try to make a good argument if and when they come out?
So I'm going to paraphrase something the CFTC complaint against HookyDAO had, which was a quote from the original founders of this company called B0X, which was the predecessor company to OokieDAO, where they said that turning it into a DAO would make it regulator proof. And we know how that went, so.
Yeah, that landed in a complaint. That's not great.
Yeah, that was quoted, I think. So I think there are definitely, yes, people who are interested in doing that, and it might not always work, as we've seen.
Okay, so there may be some interest in talking about a couple of other things. I should tell you, I only asked our panelists to be ready to talk about DAOs. But I should have known better, right? Even though I said these, what, a week, not even a week ago, that things might blow up in other areas of blockchain law, you know, in the 3 days leading up to our panel, right? So let's, because we have celebrated journalists who helped to raise awareness, is how I'll put it, about a particular SEC action. Do you want to tell us what happened last week, Nick?
Yeah, so last Thursday, which was the same day you emailed us the questions. So we actually broke this. CoinDesk reported that Kraken was going to shutter its crypto staking services to settle charges with the SEC that it had offered in unregistered security. And Kraken shuttered its US specific staking services. It's still offering staking if you're not in the US. So for anyone living outside of the contiguous 50 states, or sorry, contiguous 48, and Alaska and Hawaii, you're fine. Everyone else, you can no longer stake on Kraken. And the CFTC later said in a lawsuit that the product itself, not staking itself, but the product Kraken was specifically offering was in his view a violation, pointing in fact, or like in part to the fact that Kraken was offering returns of up to 20%, which were completely separated from what the actual staking protocol offered. That was a whole big thing for like 2 days.
2 days. Which like in normal life, a scoop like this, I mean, you would have been talking about this for months, right? And now it's like, so let's back up just a moment for those who may not know what staking as a service is. Can you explain it?
Yeah, so I'm not sure what your familiarity with crypto in general is. So really quickly and briefly, cryptocurrencies are generally secured by something called consensus mechanisms. It's when you have, you know, X amount of whatever, say, okay, we agree that these transactions being conducted are proper and we're going to process them. For Bitcoin, that's something called proof of work. So it's the majority of the computing power that goes towards the cryptocurrencies. For something like Ethereum, it's now something called proof of stake. They transitioned last year. And proof of stake means, you know, the majority of the transactions are processed by token holders who have majority and they stake it. They put it up basically and say, all right, we're going to bet our money that these transactions are processing are accurate. And if we're wrong, you know, we may lose it. So staking is difficult. If you're not familiar with it, it could be really complicated. So what happened is a lot of crypto companies in the US, Coinbase and Kraken as two examples, offered their own staking services, meaning you would stake your cryptos with them and they would process the transactions and all of that for you. Now, what Kraken ended up doing was, as I said, they offered a pretty high return. They said, you know, if you stake with us, we'll give you returns of up to, I think it was 21%, which is a fairly high return. And that drew the SEC's attention. Other companies like Coinbase claim that they offer much lower returns, that they're more based on what the actual protocol reward is. And again, the reward is just what you get for, you know, putting yourself out there. So if you're, you know, mining on Bitcoin, you have proof of work. If you're putting your computers out there, you'll get a Bitcoin reward. If you're staking on Ether, you get some amount there of Ether.
And so the idea that the SEC is now coming down and labeling things as securities that folks may not have thought was a security is going to have an interesting impact on the development of the space, right? So how are you folks at Algorand seeing this play out? I mean, it's only been what, 48 hours, 48 years? I don't know.
Well, so Algorand is a little bit different as a protocol, where the rewards are actually given to holders that are participating in governance. And so we have a slightly different, it's a proof of stake still, but it's a very different mechanism. So we're not, we don't have quote unquote a staking service per se. So, but I think the larger question of the SEC coming after a staking service is a really impactful one, because a lot of tokens are incenting their validators via these boards on the servers. But I think what's also interesting is Coinbase's response, right? Which is that they're trying to differentiate different levels of staking. There's I think that maybe I'm thinking about this incorrectly, but there's like the pure staking, which is just the rewards from the validators. And then maybe what was maybe implied is that Kraken, what they're doing is they have a staking, and then they're also adding a little bit of other, like maybe funds from lending or some other services that they offer on their own treasury, or whatever other businesses, and together mixed becomes a questionable, what is this service, right? And then you have on the other end these pure delegated staking services, right? Figment is a good example where you hold your keys, you're just delegating your assets over. And so anyways, I think it's actually quite a complex one. And for us, what's interesting in Algorand is we're actually thinking about, we're thinking about how to incentivize more participation in governance, in node. And so this question of how the SEC thinks about staking is going to really impact how we, figure out like centralization of our nodes and our servers and our validators. So it's a tricky one.
And I think there is a really important like legal distinction that both Min and Nick pointed out, that the SEC in its complaint made a distinction between proof of stake mechanisms. So if someone is directly validating, then they're kind of getting paid back in rewards for what they're doing, validating and saying like, yes, this should be the next transaction on the blockchain. And so in the complaint, the SEC didn't seem to take any issue with that type of pure proof of stake. It's when they started looking at the staking as a service, and it didn't necessarily mean that the SEC thinks that all staking services are bad or good, but it was just important to look at what they settled on and what they went after to see what the SEC thinks is important, whether or not a court would actually agree with them. But some things that the SEC had pointed out as significant was that that all the users put their tokens in a pool, and so the defendants were in control of the whole pool, and they controlled how many tokens to stake. Maybe they kept some for themselves or did other things with it. They're just saying it wasn't really that clear, and if they were giving rewards at a certain high APY percentage, which sometimes can indicate to the SEC, it kind of looks like a security when there's like really high passive income. Not always, there's never like this rule, but things like that are things that the SEC pointed out in their complaint, which like put their alarm bells off. And so it's just kind of interesting to see. And also just as a note, this is a settlement. So it just means that it doesn't necessarily apply to anyone else except for Kraken and the SEC. But people look at this to see like, what did the SEC, what are they going to go after? It's kind of like an indication of like what they may not like, but it doesn't necessarily mean that a court would agree with them or that suddenly all staking services are bad.
Yeah, y'all are alluding to kind of this difference in regulating centralized and decentralized assets or staking mechanisms. Is Algorand, is it a decentralized? Okay,
Yeah.
so when they're making these regulatory actions on a centralized exchange, for example, like would that actually have an effect on decentralized? Because it seems like this is the blowback that's coming from all the failure of the centralized exchanges, right? These regulatory agencies going after what they can. And then a second part of that question is, what do you all think is the best way of creating a regulatory framework? Like rather than doing it through enforcement, like is it these organizations like the SEC creating like policy within themselves or going through Congress? Or...
So let's take the first one. Who wants to take the first?
Yeah, I guess so.
I have a lot of thoughts around the second. Yeah, I've done a lot of thinking around the second question, but go, whoever wants. Nick, do you want to go?
The first one, I mean, I think to the extent that regulators can apply whatever they're learning from going after centralized entities to decentralized ones, they're going to. A lot of it really does seem to be more conduct based rather than the entity itself. So if you've got a decentralized entity, but you're offering, whatever securities, if you're saying, all right, we're going to act as a stock exchange. Being a decentralized entity isn't necessarily going to save you from the SEC. So stock exchange being just like a really late example, but some of the conduct that the SEC's gone after in centralized exchanges, like they're not going to care necessarily if it's a decentralized exchange. The only pause might be, how do we serve this? That's what we were talking about earlier. So I don't think, being a decentralized entity is necessarily going to stop them. On the other hand, to your point about, the collapses and disasters of the last, 6 months, 8 months now. Regulators are not happy. They've been, they've been pretty publicly embarrassed. They've been called a sleep wheel. They've, had all these things happen. People are now out, billions of dollars. We're waiting on, I forget how many bankruptcies, but, we've got more than half a dozen bankruptcy cases that are ongoing. So to the extent that regulators are going to try and say, okay, well, we want to prevent this from happening again, they're probably going to try and do something. And I think that's what's spurring a lot of what we're seeing from, bank regulators, from the SEC. We haven't really seen as much from the CFTC yet, but, they are still being active, state regulators. We're probably going to see more actions in, the short term, I would say.
Notice we've gone almost an hour without saying the word Sam Bankman-Fried.
Yeah.
Yeah.
So that was 30 years ago.
Pretty, made it out.
Well, I think, so I used to work at a centralized exchange at this exchange called blockchain.com. And I think the way to think about this question of centralized, decentralized, what's the overlap is really like, what is the government going after? I think if the government is going after specific tokens and assets that are listed on an exchange, I think that will apply to decentralized exchanges. But if the government is going after a particular service that a centralized exchange is offering, then I think you need to just kind of do this staking, like, we're okay with the protocol staking at the protocol level, but not okay at the service level, right? Then you got to tease out like what exactly it is, and it may not apply to decentralized exchanges. I think so I think it's a little bit depends on what exactly the government's going after, but as a centralized exchange, we actually use all these things to help us evaluate. Like, now that I'm coming back to it, we work with all these things to help us evaluate each asset that we list on the exchange, to go through all these, we do that all the time. Yeah, like Mark, so it sounds like it's your place. Yeah. Everybody is a really great service. We use it, and it's like and in fact we only use a few, and like we don't trust all firms, and there's only a few that we work with in all these systems. So like we're very careful about what assets because of this idea of the government come after us. I don't know if that's what I'm saying.
I know we have other questions. The second answer, my class is actually doing a lot of thinking around, should it be states, should it be federal governments? When I was on the California blockchain working group, thinking about how California should work through this, a huge issue then was how do we keep innovation in California or in the US while still protecting the public? And I would say we've talked a lot this semester around how that needle has moved because of he who shall not be named, right? It has moved quite a bit toward public protection and away from innovation. So we'll see this blowback you're talking about. We'll see how it all lays out. Questions from Zoom?
Yeah, a lot of questions on Zoom about why doesn't the SEC just publish guidelines about this? But to the point about characterization, there's questions about like how does this SEC determine, whether something is de minimis, or is there another way that you can describe these, like a staking service, for example, is say an investment contract that would, avoid some of the problems that you're pointing out. Are there things the SEC can do to characterize these differently that would make it easier for everyone?
Yeah, so I can speak on that. So we look at kind of digital assets and analyze them under the federal securities laws. So the main test is called the Howey test. It's from the 1940s, and it's kind of not related to crypto at all, obviously has to do with like orange grows and whether or not selling them for passive income was a investment contract, investing security. And so if you are a security, you essentially have to register with the SEC. It's a long, expensive process. That's generally why a lot of people don't want to do it. So what the SEC looks at, they have published some guidance in the past, but it's been a few years since they published anything. They published a framework based on, just quickly, the Howey test is a 4-factor test. If you say yes to all 4 elements, then it's likely a security, and then it would be regulated by the SEC. So when the SEC looks at these digital assets, they go through all 4 elements. So the first one is investment of money. Did you have to pay for the token? This one's pretty much always a yes. Even if it's an airdrop, the SEC has found that the first element is met. The second one is common enterprise. Is there a common enterprise? So there's a bunch of different tests, but one easy one is if it's a fungible token and all the prices of the token go up and down together, then everyone's kind of like in it together and common enterprises could be met. So like I said, it's a lot more complicated, but 1 and 2, you can assume the SEC generally wins on the first 2. So a lot of people fight on the last 2, prong 3 and 4. And that is when you have an offering of this token, did you buy it with an expectation of getting some kind of profits, like passive income from the efforts of others, meaning that you're just holding on to this token, you bought it for some kind of passive income and you're not doing anything. There's like some project team doing everything behind the scenes. And for expectation of profits, something that the SEC really looks at is marketing statements. So people are posting on their Twitter or Discord, marketing it as like kind of a investment mechanism, like you are going to have 21% APYs. It's something that SEC generally red flags. So I guess that's a long answer to your question that generally the SEC is trying to figure out if the digital asset is security. They see if all 4 elements are met, and in their eyes, if they are all met, they will consider it as
Okay, so it is 1:30 and we technically have the room until 1:50. So I think we'll take about 5 more minutes of questions, and then I'm going to ask our panelists to tell us how people can find them online, but also any advice you would have for students who are studying in this area. So go ahead, question?
So the way I see what's happening in the US right now with all the litigation processes, I personally think that SEC currently is largely influenced by the chair, and then his policy, his stance towards cryptocurrency, which is very stringent. And I also see it as SEC and CFTC trying to be the leader in the whole space of crypto regulation, and why I feel like both of them, these entities are really like going after different companies. But so I feel like just like in general, the environment around cryptocurrency in America is very difficult these days. But then do you sort of see this perhaps changing in the coming years? And then the second question I had was, I guess it's a bit related to what the person next to me has asked already, but if you look into all these like what they're saying about DAOs and stuff and all these like regulations, to me, sometimes it feels like people are not really understanding the mechanisms, like technical aspects behind. For example, like the comment about DAO having to be able to amend smart contracts, I find it very obscure because smart contracts inherently cannot be amended once they're deployed. So it's, to me, that doesn't really make sense. So I'm from like a public policy background as well. So I was just wondering, from your perspective, what are some of the ways that we could sort of also educate the policymakers or the regulators in order to make this space more welcoming for different people?
Can I answer that second one?
Absolutely.
The Blockchain Law for Social Good Center is actually offering, it's a great plug, thank you. I didn't even pay him back. We're offering neutral academic style trainings to regulators. So we have partnerships with the California DMV, who I'm training in March, the National Association of Attorneys General. We're working on a partnership with the federal defenders in the 9th Circuit. I've worked with the Comptroller's Office in California and the DFTI. We're really trying to tell regulators you need to have a balanced view of this technology. So many times I'm just asked, what is blockchain? Will you tell us what an NFT is? Will you tell us what a DAO is? Because it's really hard to learn this stuff. on your own. And so you're exactly right, that education of policymakers and decision makers is critically important to keep the space moving forward. So thank you for the question. Okay, any thoughts on the first question around the regulation in the US and where we're headed?
Yeah, I can go quickly after your areas, but, so interesting thing is that, so last year there was a ton of bills, there's probably been over 20, probably over 40 bills that have been introduced into law about digital assets. They're mostly about like digital assets, stable coins, so I haven't seen any bills that have talked about like DAOs. I think that's probably much later down the line. They shouldn't get like the basics first. But anything that any of the bills that were talked about in the past now have been wiped clean because there's a new Congress that came in January. So all those bills are wiped off the table. So if they're going to be considered, they have to be reintroduced. And obviously with all the bankruptcies and headlines and stuff, they may be stricter. A lot of people in Congress took political donations and maybe after the news want to distance themselves. So I think that probably in the Hill, it's not that favorable to crypto at the moment, but thankfully it does take a very long time to pass a bill. So hopefully by the time that does happen, things will have calmed down and things will be more positive in the Hill and it won't affect regulation. And I think that stablecoin legislation is likely to be passed first because it's like the easiest to understand and there's a lot more conversation around that. And then the more complicated topics will follow after.
No, I agree. I mean, you know, just today, the Senate Banking Committee held a hearing on crypto and, you know, I guess the two big pieces of news is one, Senators Elizabeth Warren and Roger Marshall are going to introduce a bill to try and enhance AML guidelines around crypto. And then two, Senator Tom Tillis is going to introduce a bill to try and require proof of reserves at the stations from crypto exchanges in the US. Neither of these bills, at least at this point, seem to have too much, you know, support from other lawmakers. So it's unclear if they're anywhere. But the fact that we are at a point where now, you know, lawmakers are comfortable enough to vote a point means we'll at least have this conversation happening. With the bill, like we get passed first. Hopefully, we'll see that from the House Financial Services Committee soon, and you know, at some point, the Senate will take it up. And at the very least, we'll have a robust discussion around what that would look like, what that environment would look like.
So an exciting 2023 ahead in this area. So we have a lot of folks in the room who are really interested in learning more about this. And so I'd like to ask you, what advice do you have for folks who want to learn about blockchain and crypto law? Or blockchain and crypto generally?
Sure, I mean, I think just get in there and try it. It's what I would recommend, you know, if you're interested in DAOs, join one. Although
Careful.
Oh, no. Well, I mean, I really do think though that the best way, join one that's not about investment. Sorry, no, but I do think the best way to learn is to try it out and to be part of it and maybe even start one that doesn't, you know, involve securities. But I think give it a try. I think that's for me the best way to learn.
I would say it's funny because it moves fast. So there's a lot of really free, really nice free videos on YouTube of just like how blockchain works and things like that, like quick 10-minute videos, which are fun. There's also a lot of YouTube channels that are like daily news shows with updates. And also Twitter is really big in the crypto community. And so I love following people with updates, and Nick has really great updates. I follow him on Twitter. So I think you just have to kind of like spend a lot of time like digging in and eventually you'll just get it.
Yeah, I have to agree. You know, just jump in. Don't be afraid to get weird. You know, do weird stuff. Join those, you know, odd Telegram groups. Follow. You know, play around with your own wallet. Try to figure out how to set things up. Hedge funds. And you know, just keep at it. Eventually, you'll be, you know, immersed in it, and then you're gonna regret it. But it'll be fun. I'm kidding. It's fun. It's like it's a weird place. Like you just got to be willing to get weird with it, and it will make sense.
Immersion is a really good way to do it. And I want to encourage folks to please get involved with the Blockchain Law for Social Good Center here at USF Law. If you're a student, thank you for coming to our events. Get in touch with me if you're interested in research opportunities. We're going to be doing a lot of programming later this year, and I would love to have students involved in that. If you're not a student at USF, or if you're an attorney or somebody else in this space, please get in touch with us. We are expanding. There's a lot of really exciting stuff coming down the pipeline. So it's a really fun time to be building a center like this. So, okay. Well, thank you, folks. And by the way, there is swag. If you want a t-shirt, they're over here. So come get your t-shirts. And I look forward to seeing you folks around. Thanks for being here. Thank you.